Hey guys, what's up? It's Artie of Artie's Corporate Fiction. Here, completely unprepared, but also yet very prepared to listen to the cross-examination of Mr. Blandino. I was listening in, trying to figure out this technical stuff, and I've listened to the end of his primary examination, so it's going to be very interesting to see his cross. I'm also joined by Kick, who has decided to watch this train wreck along with me. What's going on?
Oh, just sitting here enduring the awful headache that is anything that comes out of Kim Blandino's mouth.
Indeed. So right now they're in the middle of a brief recess, and obviously as soon as they're done, we'll be able to get this show on the road.
I want to confirm that,
and here we are.
Council had nothing further they wanted to ask the defendant before we get going.
No.
No? Okay.
At this point, I would say, William knows that
Okay. Mr.
This case.
Dickerson? Okay, thank you,
Okay.
Mr. Dickerson.
Yeah, and then from there, defendant has discussed a lot, still going with the defensive entrapment clearly. So he is now opened up to specific characteristics. There's a couple things that he brought up that I think the door's open up to without a hearing on those subjects. That would include specifically Shannon Nordstrom and his efforts to contact her and do the same things with her. He also mentioned several times letters to other judges. I think one in particular that comes to mind, especially given the fact that he was talking about other events in this case, come up with Talia Williams, who was sitting as a pro tem judge in this case, in Justice Court. He dropped off a similar letter to her at her office in November of 2019. In addition to that, I think that he's also opened the door to the stay away order that was ordered in the Justice Court, since he wanted to talk about the parameters of what occurred within the TPO hearing, and it ultimately only going on for 30 days. I believe that he's also, through his actions or through his testimony, opened the door on the fact that he has been deemed a vexatious litigant by the 8th Judicial District Court, as well as that he's previously filed appeals out of the Justice Court and has also been banned from other courtrooms.
You want to go into hate that he's been deemed a vexatious litigant? What does that have to do with this?
I think it has to do
That's a
with
good question.
discussing his intent when he deals with the courts, specifically the vexatious litigant order, which we have a certified copy of, indicates that Mr. Blandino's filings are repetitive and appear to be filed merely for the purpose of harassment. So we have court's findings previously that the defendant is filing things and doing things within the court for the purpose of harassment. It goes outside the scope of what outside of his proper intent, which is just to help the Commission on Judicial Discipline. And then he knew at the time that he was banned. He knew at the time he was kicked out of Mr. Federico's courtroom on that day. He already been banned from other courtrooms. So this wasn't something that was new to him, that he didn't know could happen. And that happened specifically in Judge Baer's court. he was also found in contempt.
No. I don't have my heart rate monitor on, guys. No.
Artie, I actually have a question for you.
What's
I
up?
know that you said earlier them bringing up the him being a vexatious litigant. You know, you were concerned about relevance, but they're also bringing up the other background information, his banning and things of that nature. Would you object to the relevance of those statements that they just made?
I would, because
Wasn't properly found in contempt.
they don't have enough. They don't have enough. I mean, it would be one thing if they were trying to make an establishment that. I mean, I understand what Dickerson said, that is to establish his intent behind it, but
Where defense counsel stands.
I don't know what that.
I feel like it's asking a bit too much. I would probably object on relevance plus potential character grounds.
Okay, so establishing character, this type of information would be something that they'd put at the beginning or in the initial motions.
I don't know what the facts would be, so.
Yeah.
Can you make an offer approved?
Yeah, so the offer
That I don't know.
we have for Talia Williams would be that as follows. On November 25th, 2019, Mr. Blandino called and left a message for Ms. Williams at her office. As then, in addition to that same day, prior to calling the message, he dropped off a few sets of paperwork to the receptionist there at her private law office after she had sat as a judge in the justice court case related to this. And so the letter is urgent service of process to Talia Williams on November 25th, 2019. He says that to Talia Williams in her known capacities, pro tem judge, licensed attorney, master in case A-19-797388B and female human being from Kim Blandino, parens in quotes, Kim, end quotes, and parens, in all Kim Blandino's capacities, being, in parentheses, believer and the creator of all things, and his only born son counts for Kim Blandino in all legal matters as attorney for Kim Blandino, investigative journalist, and investigator of judicial misconduct and corruption, to which capacity Kim has volunteered for and receives no pay or remuneration for, and who tries to settle matters with offending judges to avoid having to file complaints with the Nevada Commission on Judicial Discipline, parens, quotes, NCJD, end quotes, and parens, this capacity anyone has the power to do under the Nevada Constitution, and the NCJD has objected to my verbiage describing the same, and the state has in fact charged Kim for impersonating a public officer, which charge is totally false. Kim welcomes any suggestions as to shorten verbiage that describe what Kim is doing that adequately and specifically describes the same, period, and parens, a male human being. Refusal of mail which contains important legal information, and that Talia must recuse from case 19-797388B. The important legal mail that was refused on or about September 4th, 2019 by Talia Williams.
Okay, can you just give me a summary instead of reading?
Yeah.
Sorry,
Yeah.
I mean, it's.
So essentially what he tells her is that he needs her to recuse off a case that he believes that she is hearing, this Apache Mills hailing case. That ultimately is coupled with him saying Williams must now contact Kim to resolve these wrongs without Kim having to go to the Commission on Judicial
Okay.
Discipline.
So the same.
Same thing.
Type of thing.
Yeah.
And she's a pro tem as well?
She is. She was at least at that time.
Okay. And, so her private law office?
At her private law office.
He didn't have any chambers here. And she substituted the others.
Okay. And, Shannon Nordstrom?
Yeah, Shannon Nordstrom would testify. She's been contacted. Well,
What do you mean she would testify?
so she would testify in rebuttal in this case.
Oh, okay.
Yeah, that Mr. Blandino has had a history of sitting in her courtroom, watching her, and apparently sending writings of some sort to the court or to her, but that on April 25th, 2019, Mr. Blandino called her and left a voicemail, which we have a copy of and has been provided to the defense counsel, indicating that she needed to resolve the issues with him. He was reaching out to her because he just had something going on with Mr. Federico, and so he gave Mr. Federico a last opportunity to resolve things, so he wanted to give her one too and make her aware of it, and then he sends her the April 25th letter that he provided to Mr. Federico.
So what does she have to do with it?
Well,
I don't
she-
understand what she has to resolve with it.
yeah, I guess whatever he had in his mind, but she did wrong.
Oh,
Yeah,
okay.
yeah.
Violations of the code.
So the defendant has specified on the record violations of the code.
Okay. All right. So you want to go into those two things, and then the stay away order?
Yeah, I believe the stay away order has become relevant based upon Mr. Blandino insisting on testifying to the events in the temporary protection order case, that the.
So, so
temporary
basically,
protection order was
because it sounds like
extended
what
for 30
Cam
days.
Blandino was rambling about, he opened the door for the state to bring in a whole bunch of more
I think that it's become relevant.
negative
There's been an
aspects
ongoing-
of Blandino throughout this saga
It's,
as a result of his own testimony. I think that's what the Dickerson just alluded to.
I would agree.
I'm sorry, I didn't quite catch that. Can I have that repeated?
There's a stay away order pursuant to his bail conditions. So, I know Mr. Blandino's aware of it. All right, and then the vexatious litigant order is relevant because,
That the court has found that his prior filings were intended for harassment and not out of some innate intent and desire to further the public good, as he testified as his overall thing.
are those all the issues you want to go into on cross? I just want to make sure before I ask
We,
Mr. Bateman to respond.
we had the one as well, and it is related in this way. So both the issue of the vexatious litigant order, which related to the case that he filed a complaint on Judge Herndon, where he was ultimately deemed a vexatious litigant, and then the appeal
767.
another city case into the district court in about 2014, where he was ultimately banned from the courtroom because he was representing other people. That was with Judge Baer, and he testified to that, the filing complaints on Judge Baer and Judge Herndon. That's it. That's the totality of what I'd like to get into.
Okay, Mr. Bateman? Mr. Blandino, you've got to let him respond to the court.
Judge, I would say that he has not opened up the door on
I mean, his
On
character
these,
is clearly,
you know-
I mean, you agree when you put forth entrapment, his character is clearly an issue.
I do, I understand that.
Okay.
The one thing I think that the vexatious litigant, I think, is different. I think anything regarding that would just characterize his testimony that he files complaints with the commission to make things a better, I don't have my notes for what it said, but we would have said to make the world a better
Public
place,
good.
so those, along those lines. Not necessarily civil filings, and I think that would confuse the issues. And I think anything related to a filing that's not in regards to complaining with sending a complaint to the commission. We've heard from Mr. Dyla, he has the right, anyone has the right to file, and so I think as far as the vexatious litigant, its prejudicial value, I think, outweighs its probative value, and then I think it would confuse jurors, because that vexatious litigant isn't related, that designation as a vexatious litigant is not related to his filings with the commission, which is specifically an issue here as it pertains to Mr. Federico. Now, so I understand this character is an issue, and I know I was given these letters. I didn't bring, 50 baker's boxes, but I think as these letters relate to anything, anything other than a complaint with the commission, I think it risks confusing the jurors as to what his stated intent was, what she said in regards to complaints with the commission, is to make things better.
Well, would anything related to Shannon Nordstrom or Talia Williams, those were complaints relevant to him appearing in front of them, correct?
Correct.
Okay.
So, I mean, yes, and he certainly helped Mr. Dickerson make his point by not keeping his mouth shut.
Yeah, he
So,
fucked
but
himself.
I do think there's a difference to be drawn on the vexatious litigant point, and it would be confusing to the jurors and unfair to Mr. Blandino.
Anything else, Mr. Dickerson?
No, Your Honor, we'll submit on that.
Okay. I will allow you to go into these issues with the exception of the vexatious litigant issue, although it may be probative. I think any probative value would just be outweighed by unfair prejudice. So.
Which I kind of agree.
Regarding, I'm assuming Shannon Nordstrom and Talia Williams they're both pro tems?
That's correct.
Okay.
Well, yeah, it would be a pro tem position for Shannon Nordstrom. She's an appointed magistrate.
She was,
Okay, so
she was a traffic, I think her official title was, I know he doesn't appear in the municipal court, but I think it's hearing commissioner, or traffic
Okay.
commissioner, I believe was her title at the time. I believe she's been appointed now in Department 6 in the municipal court. For Hastings.
Okay, anything
This
else
is,
before we bring them in?
And so as far as the, was your ruling the same on the prior City of Las Vegas appeal that was filed and then ultimately him being found in contempt and being banned from the courtroom?
In the city of Las Vegas from Newport?
So once he appealed up to district court,
Okay. On the traffic matter in front of Mr. Federico?
no, this was a separate matter coming out of the city.
Okay.
I have a certified order of contempt and recusal here.
What's this one?
That's a pretty quick petition, says that he.
And that happened in the city of Las Vegas?
So it happened in the 8th Judicial District Court. The case that he appealed was out of the city of Las Vegas.
Oh, okay, and then, it came here? And so during his appeal hearing?
During his appeal hearing, yes, he was found in contempt and Judge Fair recused.
Okay.
So I'll give the court
Oh,
number.
I'm sorry, so this,
This should be.
I didn't catch all of that.
This should be a copy of that for the court to review.
Can you just double check?
Sorry. Yeah. Yeah, first, Sharon?
You may. Thank you.
Anthony, I'm not sure. It almost sounds like he might not. Yeah, I'm trying to wonder if.
You don't have that petition for rehearing, Mike, because they said it was not properly found in contempt.
Hold on.
They just let the 25 feet thing stand, that's all. But they said it was not properly found.
They've been,
That doesn't mean that negates what they found, that they wasn't properly found and condemned.
I'm a little confused, Artie.
Can I get my phone?
Kim is no longer on the witness stand. Has the prosecution rested?
Well, the state had already brought their case.
So no cross?
I'm wondering, that's what I'm kind of confused too. I'm wondering whether or not that they were just going to go through this procedural matter first and then begin the cross, or if the state is actually not even going to bother with a cross at all, and they're just going to bring in these redirect witnesses.
Yeah, considering that he completely blew past his Fifth Amendment right against self-incrimination, it doesn't feel like the state has anything else that they can bring against him.
Yeah, true.
And there was much rejoicing.
The appeal was ultimately dismissed before the appeal in this case. So he knows who's recourse, and that he's also incident from the courtroom.
Here it is, right here, Ben. Argues that
Okay, so Judge Bear said you can't come in this courtroom,
the district court.
and then he recused on Mr. Blandino's appeal. And you want to go into this because?
I want to go into this essentially to show that, you know, he's previously filed appeals in the city of Las Vegas cases before, and that he knew the process, he knew the recourse. But there, I mean, it was dismissed.
Okay, Sarah's okay, that makes sense. What Sarah said, the jury's not even in yet. They're going through these procedural matters before they bring him back in, and I assume that's when we'll find out whether or not Dickerson's going to put Blandino in cross.
Okay. Yeah, I didn't notice that they were missing the jury icon in the top left there.
Yeah.
Really got to throw it out to ONJ for their format, giving us bit rates, who's watching, who's actually in the courtroom. So huge shout out to them.
Just real quick, I just got a message from our Nevada judges. They said there's somebody in the courtroom yelling at Kim,
Yeah,
screaming at him.
Go into this.
What?
Judge Bear.
And that's why he was pulled down at the current moment.
That's it, thank you very much.
Oh.
Can we bring him in? Ms. Blandino, you can come back up on the witness stand.
All right.
Here
so
we
I guess
go.
We get our cross.
Yep. Here we go.
And you can bring the panel in.
Before they come back in, there's one other thing on
Okay.
it. As part of reciprocal discovery, Mr. Blandino provided me a copy of the Commission on Judicial Discipline complaint that he filed against Mr. Federico. He filed that in August 2019. I obtained this from the defendant and his counsel, and what I will be getting into here, just so the court's aware, is that throughout this complaint that he filed after this case existed, Mr. Blandino repeatedly and specifically asked the commission for judicial discipline for immunity, over and over and over again. Yes,
Oh, for immunity in this case?
in this case.
Well, they obviously can't do that.
They have legal authority to do that under the law.
To grant immunity
Yeah,
in this specific case?
Yeah.
Okay,
That's my read of it, actually.
okay.
So I'll get into the date and I'll get into him asking for immunity.
What is being implied here?
Okay, we can bring them in. You can bring them in.
All right, Kurt. All right, we're entering jury, please. Thank you, everyone. Please be seated.
Does this case stipulate to the presence of the jury panel?
Here, Your Honor.
And the defense?
Yes, we do.
Thank you. You may begin your cross-examination.
Thank you very much. Mr. Blandino.
He loves this. He loves
you're
every
not
second of it.
investigator for the Commission on Judicial Discipline.
I'm an unofficial investigator, yes.
So are you telling this jury that you are an investigator for the Commission on Judicial Discipline?
Unofficially, yes.
No, you're not, sir, right? You sat here.
No, that's not true.
You heard the testimony of Paul Dyla, the same I did, right? That you are not and you never have been an investigator for the Commission on Judicial Discipline, correct?
He wasn't
Correct?
specific.
It's a yes or no question, sir.
Repeat the question.
The question is.
Oh, he
you are
ain't
not
giving him
and you never have
anything.
been An investigator for the Commission on Judicial Discipline.
I disagree, I'm an unofficial one.
You are absolutely not, and that's the bottom line. You gonna agree with me on that?
No, I don't agree with you. I disagree 100%.
Okay. You're also not an attorney, right?
I'm an attorney, and in fact, for myself, when I appear for myself, and I'm an attorney, in fact, for Evelyn Pendergraft, both by regular attorney and power of attorney, and for her durable health care power of attorney. I'm an attorney, in fact, which is different than an attorney at law, but in terms of I can represent her, I can sign for her.
That's
I can
good.
sign medical.
So you can't admit to this jury that you're not an attorney, right? You can't admit to them that you're not an attorney?
I'm an attorney, in fact, for myself when I represent myself.
Okay, but you're not an attorney, correct?
I'm not a licensed lawyer.
Okay, and you're not an investigator for the Commission on Judicial Discipline. Can you-
Unofficially, I am. Yes, sorry, I
Okay.
disagree.
So you can't admit to this jury that you're not.
I'm not going to admit to something that's not true. I'm sworn to tell, not sworn, I promised I would tell the truth, the whole truth, and nothing but the truth, and you're trying to bury me with half-truths.
Okay, so in fact, the Commission on Judicial Discipline has in fact sent you a letter, a cease and desist letter that said, stop calling yourself an investigator for the Commission on Judicial Discipline.
Which I cured
Is
with
that
a
yes, is it
response.
yes or no, sir?
Did they send that letter? Is that what you're asking?
Yes.
Yes, they sent that.
Okay.
And I received it from jail.
You've never received any training from the Commission on Judicial Discipline, correct?
Not official training, unofficial training.
I don't,
You have
Oh my
never,
God.
been to any sort of work function for the Commission on Judicial Discipline
Define work function.
where they train their employees.
In what venue are you talking?
Oh my God.
Get to know, right?
I don't know, I want clarification.
he won't
It seems like
answer.
an ambiguous question you're answering.
Okay. All right. So you admit to doing everything in this case, right?
Admit to doing everything, what does that mean?
Well,
That's a fair question. That's a fair question.
The objection sustained.
Yeah, that's a fair question.
I guess we'll just go through each one, right? So you admit to, on April 8th, 2019, going to Mr. Federico's private law office at 9950.
I'm sorry, no, I don't agree.
Please let me finish my
It's
question,
a
sir.
public law office,
Please let me finish.
open to the public.
Please let me finish my question before you answer, okay?
Okay.
So you admit to going to Mr. Federico's private law office on April 8th, 2019?
I didn't go into his particular office, I went into the reception area. I never made it past the reception area.
Okay, so that's a yes.
No, it's not. Here it gets a bad question. I went to the reception area of those offices.
Oh my
and
God.
Even as he testified, he never came out from that little hideaway thing he had, whatever he called it.
Okay. You were there for a while, correct? And in fact, you did write the note.
Sure, that's not denied.
Like I said.
In my
He's
file.
such a he's weaseling so bad.
No, I'm
Did
not
you go to his law
accusing
office?
everything.
I didn't go to his office. I went to the lobby.
Okay, I'm showing
I'm not
you-
talking.
Say you're gonna
It's
go
like
on
I'm not
my
talking about your his
Three.
literal office.
Right? Is that the note you wrote?
No.
Is that a copy?
It's a copy of the note that I wrote, to be specific.
Okay.
But I think it was green paper is the original. Is that green on the screen that you're showing?
It's not,
I think
sir.
it was green.
Okay.
Yeah.
So is this
Copy
is
of
this
the
a
note.
copy of the note that you wrote on April 8th, 2019?
Right.
It is?
Yeah, it looks like a true and correct copy.
Okay. And at the top, you identify yourself, Kim Blandino, right?
Right.
You identify your email address, kim43792@firstbank.net, correct? Again, you gotta let me finish my question before you answer, sir, okay?
Oh, I thought you were through, sorry.
Okay.
Apologize.
And you identify your phone number, 702-219,
Oh, it's a 6.
5656.
Handwriting.
You wrote that,
Yeah.
and you wrote the rest of this note, correct?
Yeah, I don't see any alterations at all.
Okay. You addressed it to Michael Federico, pro tem judge, alternate judge, City of Las Vegas.
Yeah, see, he's got a title alternate.
It's a yes or no, sir?
Yeah, that's what I wrote.
Okay. In addition to that, you began this note off, I am ready to begin filing my complaint against you. Right?
Right.
Okay. Right down here, you indicate I'm going to give you an opportunity to negotiate settlement. Is that right? You wrote that?
Yeah.
Please let me know within the next 10
And there was
days.
much rejoicing.
Correct?
Yeah.
And then you tell them about your past 2 complaints to the Commission on Judicial Discipline, right?
Right.
Then you sign that, is that your signature right there?
Yes.
And your phone number,
Well, it's a copy of my signature, to be specific.
what is there on the paper is your signature, right?
Yeah, there's a
Okay.
copy of my signature, yeah.
It's a copy of the paper that had your signature on it.
Yeah, I mean, what I'm looking at is a copy of my signature, right?
Yeah. So it's your signature.
Yeah,
Yeah. And then your phone number,
right,
702-219-5657.
yeah.
There's also that sticky note, right, on the second page of that? Is that a copy of that?
Yeah, I asked her for a sticky note, and I put that on there.
And you said you got the jabs.
Yeah. Should have spelled out what that was, Jefferson Audio Visual System.
Okay. And so you admit to that?
Yes,
Okay. And then you admit to, on April 25th, 2019, going to Mr. Federico's courtroom.
no.
You just testified about it.
It's not Mr. Federico's courtroom, he's only temporarily there.
Okay,
I looked through the window and I saw that he was on.
I'm going to stop you right there. I'll do the questioning.
Okay.
You're no longer testifying
All right.
in the narrative, okay?
I just want to be
Hey,
accurate.
me too.
There's-
That's good.
Yeah,
Thank you.
yeah.
This is the way it's going to go.
Right.
And now you're going to get questioned.
Well,
And-
if,
and-
Mr.
stop.
Blandino,
Stop.
I'm
just
sorry.
wait for the question.
Okay. And so, Michael Federico was sitting as a pro tem judge on April 25th, 2019, right?
Well, actually, alternate judge, I found out later. Alternate judge
Okay.
is the title there.
Okay. So you agree with me, yes?
Agree with you what?
Yes, Michael Federico was sitting as an alternate or pro tem judge that day, correct?
In courtroom 1C on 20?
Yeah,
Yes.
April 25th.
Well, actually,
It's April 25th, 2019.
yeah,
Yes.
I think it was that morning. I don't think he did the afternoon session.
Okay. And you go to that courtroom where he was sitting as a judge, right?
Hmm.
Is that
Is that a yes?
Yes, oh, I'm sorry.
You can see before you enter the courtroom that he's in fact sitting there as a judge, right?
Oh, yeah, I saw it before I got up to the front.
Okay. You go into the courtroom and you sit down, right? Is that a yes?
Yes, I'm sorry. I'm sorry.
Okay. And you said that you've been like doing all kinds of stuff throughout the courthouse that day, right?
Right, it was several locations, more than several.
And so when you come to the courthouse, that day, you're just going all over the place?
I believe I had business to do on one or two locations, a cashier specifically. I mean, if you want me to refresh my recollection, I could look at that document again. But, and then when I go to the courthouse on things like that, I kind of let God lead me as to where to go, what courtroom, and the marshal's kind of perplexed. Where are you going next, Mr. Blandino, he asked. It was John Gurka on that day, real nice guy. Anyway, so I said, where are you going next? And I said, well, and then I would move here or there, depending on how the spirit moved me.
Okay. And so this day, it led you to Mr. Federico's courtroom, right?
Right.
And
I was surprised.
did you come through the security check gate when you came in?
You mean where the scanners are? and everything?
Yeah.
Oh, yeah.
Okay. And when you go through there, do you have to take your belt off like everybody else?
When I'm wearing a belt, yeah.
Okay. You have to take your shoes off like everybody
Not sure
else?
where he's going with
Yeah,
this
then
one.
you have to take shoes off, but now you don't. So
Okay.
they have modified that subsequently.
Okay. And in fact, you wear shoes that tie generally, right?
Generally? I'm trying to think about that. You mean as opposed to like Velcro or something
Yeah.
like that? Yeah, mostly they tie, but sometimes I can slip off my tied shoes and then slip them on like they're slip-ons.
Okay.
Yeah.
But usually tie.
Yeah, I think that's fair.
And so, when you walk into Mr. Federico's courtroom that day, you have this gray tray in your hand. What is that?
I thought I explained that. What oftentimes I do, because it takes quite a bit of time to put the wallet, belt, and all that stuff, I found that I'm usually waiting in line somewhere along the way, or in waiting, or on the elevator, I can dress while I'm there. It's kind of a time management thing. So, and I kind of make a joke to different people when I see, it's kind of time management. Then as soon as I can find my way back, if in my travels, I'll drop the container off. Sometimes I don't drop it off until I go up the exit, and I go like under the rope, and I put it on the table so it saves somebody the effort of.
So it's fair to say that gray bin came from security checkpoint?
Yeah, sometimes I bring my own.
Oh, you bring your own security checkpoint bin to the
Yeah,
courthouse?
right in, yeah, I done that.
Wait, he takes the bin with him to court?
But not this.
Like he doesn't put it back?
Not to my recollection,
Okay, the one that you had there that day
yeah.
was in fact.
He stole the bin?
Basically, the 31.
That's what it sounds like. He took the airport bin, security bin with him as like a carrying case to court.
No,
This appears to be April 25th.
He did.
Right.
Okay.
that's the most
Probably
petty
right there. When
shit.
Your shoes are still on time from the security checkpoint, is that right?
Are they? I don't know.
What is even the what is even the relevance here? Come on, this is just like humiliating him.
No. I think I know where Dickerson's going with
It
this.
looks like just.
I think I know.
Laces are loose, right?
What do you think?
No, I'm saying.
So
it looks like
Dickerson
this
is
one
probably
utilizes
establishing
this.
that Blandino
Okay,
has
well,
to
the jury can watch that and
put
judge that
himself
themselves.
Okay.
under the jurisdiction of the
And
court to
then,
follow the rules. And that means from door
you
to
admit
courtroom and back out.
being kicked out of that courtroom, correct?
Well, I think that's evidence that you say it shows that. that's what happened.
I was thinking about that too, right?
I
That
didn't ask what the video showed, I asked, you admit to that, right? You admit to being kicked out of that courtroom, right?
Are you asking me to determine whether this
we'll
is
see.
an altered
Let me
video?
let's watch.
I'm asking you admit to being kicked out of the courtroom, sir, correct?
Well, not literally kicked. No one took a shoe and kicked me out, but he said, get out in 10 seconds or you'll be found in contempt.
And he said it's because you came to his private law office, right?
That's what he said on the video, right? Because you came to my.
No, that's what he said in real life, when you were there, right? He told you, get out of my courtroom because you came to my private law office, right?
No, I
It's a
didn't.
yes or no question, sir.
No, he didn't say it that way.
Okay?
What he said was, because you came to my private office.
Oh my god, this fucking guy!
Okay.
This fucking guy!
So then you tell him.
Oh my
you're out of
god.
order.
Well, I think I said first, I think that's not true. And then I said later, that's I think you're out of order.
Okay.
Yeah.
But in fact, it is true, you did go to his private law office on April 8, 2018.
No, well.
You already admitted to it, right?
No, what I'm saying is I don't think that's true that you can kick me out, is what I was trying to get across.
Okay. Because it is for sure true that you went to his private law office on April 8, 2019.
No, I have that transcript if you'd like me to show
It's a
it.
yes or no, sir.
What was the question again?
You did go to his private law office on April 8, 2019.
No, I went to a public office and I went to the reception area. I don't know why you want to be
Okay.
mischaracterizing that. I'm being very clear on that issue.
Okay. And then,
His
so
office
you would,
is-
hey, there's no question, Penny.
Yeah.
And so you admit to all of that, the events of April 25th, 2019 at the courthouse, right?
Yeah, that, and he said, don't stop
Okay.
people.
It's a yes.
Yeah,
And he said, don't stop people.
right,
And that was what you heard that day.
right.
Okay. And so you then admit to this jury, you go home, right?
No,
At some point in time that day, you go home.
no, but right from there, I go to make a customer feedback form. I testify to that.
Okay.
Are you testing my memory?
After your customer feedback form,
Yeah,
you go home.
right.
And then you get on your computer
Well, yeah, I start typing on it.
and you start typing the letter of April 25th, 2019. Right. And then in the afternoon, you go back to Mr. Federico's private law office at 9950 West China.
Yeah, I don't want to wait for the mail. I wanted to get it right there.
It's a yes.
Yes.
You go up there with this letter that you typed and attach the customer feedback form.
Right.
And in addition to that, you've also included 2 letters from the Commission on Judicial Discipline
Right.
that you say are from previous complaints you filed.
Yeah, I guess Judges Bear and Harmon.
Because you want to make sure that Mr. Federico knows that you're serious, right?
No, I don't think that's what I demonstrated. I wanted to show him that I wasn't filing frivolous complaints.
Okay.
So I think it's different
So
when you say serious.
it wasn't enough when you wrote in your note, my past 2 complaints of the Commission on Judicial Discipline resulted in letters of caution. You wanted to make sure that he saw the letters that you got back from the Commission on Judicial Discipline, right?
Well, anybody can make an allegation.
Is it yes or no?
No, repeat
You
the
wanted to
question.
make sure Mr. Federico saw the letters that you got from the Commission on Judicial Discipline, right?
Well, I think that's why I included them, sure.
Okay. And so you go up there and you drop off the letter of April 25th, 2019, right?
Mhm.
And that's what I have on the screen here. A copy of that states Exhibit 4. Is that the letter?
Yeah, that's a copy of it.
Okay. Let me go ahead and just zoom in a bit here so you can see it a little bit better. there at the top, you put the date, right?
Right,
April 25th, 2019, is that correct?
right.
And then you address it to Michael Federico in his capacity as a judge pro tempore, correct?
Right, and that was another screw up, they should have put alternate judge. Because if it's judge pro tempore, that would be when he sits on the justice court.
Okay.
Or justice pro tempore, but he's alternate judges.
Oh my God.
Just his capacity as a judge, right?
Yeah.
Okay. And then from there, you say that it's from you, is that right?
Right,
And then you title this letter, Desire not to have to file a formal complaint with Nevada Commission on Judicial Discipline.
right.
And you abbreviate the Nevada Commission on Judicial Discipline, NCJD.
Yeah, I always do it in that form because it's easier than writing commission.
Right, so throughout your letters that you've provided that are in evidence in this case, every time you say NCJD, it's the Nevada Commission on Judicial Discipline, right?
Any yes?
Oh, I'm sorry, yes. Sorry, Judge.
And then here, on the second paragraph here, you indicate that you are an unpaid volunteer investigator for the Nevada Commission on Judicial Discipline.
Yeah, to investigate judicial misconduct and corruption, yes.
But you're in fact not an investigator for the Commission on Judicial Discipline.
No, I'm unofficial investigator, that's not true. Why do you keep repeating that? I mean, that's been asked and answered, I think. I'm unofficial.
He voluntold
I'll
himself.
determine that.
Oh, I'm sorry.
So you need to
Yeah.
answer the question.
No, that's not, and it is true that I do that, but I do it unofficially. Which now is what I say, more clearly, in brackets, I put, which means unofficial. So it's absolutely clear then that I'm not an official, nor trying to pretend to be an official officer, agent, or employee of them. That's what I thought. Unpaid volunteer would mean to an average person, of average understanding.
I mean,
I'm an unpaid volunteer firefighter too. I fought some fires and put them out. I'm an unpaid volunteer.
are you an unpaid volunteer detective for
Yes.
the Las Vegas Metropolitan Police Department?
No,
Okay.
no. I work with them though on occasion.
Okay.
I provide them information. I did
Yeah,
this the
listen.
other day, made a 311 call.
You made sure to tell them that you were there in that capacity as a unpaid volunteer investigator for the Nevada Commission on Judicial Discipline, correct?
Right, to investigate judicial misconduct and corruption.
Sure. And in
But
fact,
also an investigative reporter, which I've got proof of.
you could have just said that you're an unpaid volunteer investigator to investigate judicial misconduct and corruption, right?
Well.
It wouldn't be the
You say I
same,
could
right?
have, your question is, I could have said that?
Yeah,
Well, I could have said a lot of things or written.
but you
them.
didn't,
No.
right? You said that you're an investigator for the Commission on Judicial Discipline, right?
Well,
It's a yes or no, sir?
yeah, I did put that there.
Then
Oh
you
my
admit
God.
to coming to his law office
This
to
is-
see if you could meet him man to man.
This is a
and see if
train
you could
wreck.
resolve the complaint without having to use the scarce judicial resources and Nevada Commission on Judicial Discipline resources, right?
I think I said publicly listed offices there, it looks like to me.
Is that a yes then?
To see if I can meet you man to man. Yeah, publicly listed offices, yes.
Indicating that you wanted to do it without having to use the Commission on Judicial Discipline resources, correct?
Right, which indicates that I'm not really an official of them.
Oh, yeah?
Yeah.
So you go on here. So to avoid having the Nevada Commission on Judicial Discipline subject this complaint to their protocols, I once again reach out to you to resolve this matter between you and I or your attorney if you wish an intermediary. Is that right?
Yep. Yes.
And there was much rejoicing.
Which their protocols, not our protocols. If it was, I was an official, it would have been our protocols.
Oh,
Clearly
now,
they're-
oh, here we go.
They're separate from me in terms of officially, because I'm unofficial.
You go on. I believe you should seriously consider resigning, right?
Yes, because I don't think he has a temperament.
We should meet and see if these matters can be settled for all concerned and for a multitude of reasons as cited in part above, right?
Yeah,
So-
because you can't do something in a letter where you can meet face to face and do thing. That was what was important, is a meeting. So you could have a meeting in the minds, you know? You know, paper, I'm old school.
Okay,
you know,
there's no
paper
question
is-
pending, sir.
Yeah, okay.
And so, you remember when you testified during your initial direct testimony, and you said, they just told me never to come back? That would have been it, right? I would have just filed my claim and been gone.
Right.
And you admit that on April 25th, 2019 in the morning, Mr. Federico, sitting as the pro tem judge, kicked you out of his courtroom because you came to his private law office and told you not to stop people, correct?
No, I don't
Okay.
agree. That's a compound question. I can't answer that with a yes or no.
Okay, so you don't agree with your answer.
No, it's a compound question. I can't answer it as asked.
Cool, you already answered it. And then,
On public law.
so you admit to the events of April 25th, 2019, is that right?
Admit to,
Right. I mean, this seems to be asked and answered several times.
it does, to me too as well. I agree.
Okay, Bateman, come on, man. You can't have the judge objecting for you.
We'll go
He's a
back to
broken
that.
man, Artie.
We'll go back to State's Exhibit 4. Here, is this the customer feedback form that you attached to your April 25th letter?
It's a copy of it, looks like.
Here on the customer feedback form, you say your business in court, investigative journalist, and investigating judicial misconduct, right?
Right.
You didn't write that I am a volunteer
Well, you can
investigator.
see there's not a lot of
Hey,
space.
hey, no question yet, sir.
Oh, I'm sorry.
You did not write that I am a volunteer investigator for the Nevada Commission on Judicial Discipline with this document that you gave to the court, did you?
No, I didn't.
Okay. And you go on to discuss the events in a series of pages of April 25th, 2019 that occurred in the courtroom, is that right?
Let me maybe scroll up and flip through a thing. I think it was 8 pages or something like that. How many pages was it? You said several. 2, 3, I didn't number these, did I? 4, I'm not seeing, oh, there it is, there's the numeral 5. Was it 8? Several to me always seems like it's 5. I don't know why. 6, 7, 8, yeah, 8 pages. Is there another one?
I apologize to you guys that I'm getting Comcasted. I'm still seeing some of the errors.
And then we go to the back pages,
Right, the exhibits.
and we look to the left, right?
Yes.
The ones that you previously referenced in your note of April 8th, 2019, right?
Right, that's true. That's the ones I was referencing.
Okay. You just wanted Mr. Federico to see this, right? Is it yes or no?
I'm sorry, repeat that question?
You just wanted Mr. Federico to see this, right?
Yeah, I wanted him to see it. I put the notation up there, Herndon complaint, and then Bear complaint on the other.
So we'll get to that. So you write Herndon complaint on this,
Right.
and then on the next one you write Bear complaint.
Right.
Because the Commission on Judicial Discipline didn't tell you that here, this first one was a complaint that you filed on Judge Herndon, right?
Yeah, they just go by the case numbers there. So I have to look at the original letter I put the complaint on. They said, here's your number. And then when they refer to it there, they have a RE case number. Then you know which one that refers to.
And there was much
But I don't know
rejoicing.
if they did that for that confidential reality, so that if somebody got a copy of that letter, they can't.
Thank you,
tell. I'm
Area
guessing
Scout.
That's why.
In fact, it is
Yeah.
confidential,
Yeah.
right?
As far
Both
as
of-
they're concerned,
Both of these are
Yeah.
confidential, right?
as far as they're concerned, I can publish it wherever I want.
Okay. Nothing in this letter says that they issued a letter of caution to Judge Herndon,
You have to know how to read the language there.
Oh, it's a specific code that you gotta dissect?
Yeah.
Okay.
Oh.
Do you agree with me?
My training allows me to know that.
My
You got no training from the Commission on Judicial
Well, that's
Discipline.
my unofficial training, see,
Oh, like your.
like Jedi stuff.
Oh, they are
do you
going
agree with
after
me,
each
though?
other now.
Nowhere on this letter does it say, we issued a letter of caution.
No, not those words, but if you look at this
You're
language, I'm sorry,
interrupting the district attorney.
I'm sorry.
Nothing on this letter says that there was a letter of caution issued to Judge Herman, correct?
No, it's inferred,
Oh, but nothing in here says that, right?
not specifically.
Okay,
You have to read the code.
okay. Same here with the one titled bear complaint, nothing in here
You
says.
notice it's the same verbiage.
Yeah, so nothing in here says that they issued a letter of caution to Judge Bear, right?
Not specifically, it was
Okay.
inferred.
And in fact, the Commission on Judicial Discipline has never told you that they've issued letters of caution on either of those.
No, not specifically,
Just that they were
but the
dismissed.
reports show that it does.
Just that both of them were dismissed, right?
Yeah,
Okay.
and, well, I'm sorry, go ahead, there's not a question pending, I won't step on your toes.
Okay. And so, then we get to April 29th,
And there was much
2019.
rejoicing.
You get a call from Mr. Federico on the same.
Yeah,
phone,
Amanda.
working on all these documents,
Right, right.
You say.
All of this for a
That's fine,
stupid traffic
you-
ticket.
Just woken up from taking a nap with your feet up on your desk, right?
Mhm.
Your daily.
Well, I didn't tell him that, I said I was shocked and,
No, that's what you told the
still-
jury, right?
Yeah, I was still a little groggy, but I don't think I said that to him directly. I got up from it. I'm not sure, it could have.
Okay. No worries. But you told this jury that, right?
Oh, yeah, because that's true.
And that's your usual nap that you do every day, is that what you're saying?
Mostly, I mean, unless I'm doing physical work, if it's just office work, yeah, I need that nap, but physical work, I'll blow right past it.
Okay. And you told this jury that you got the call, and I wrote it down. I was happy and surprised.
I thought I said shocked and surprised, is it happy or,
Yeah, happy and surprised.
it's happy and surprised, okay.
That's what you were?
Yeah, I had actually had the idea that. he-
That's
Yeah.
the question.
Yeah, okay, I'm sorry,
Okay.
yeah.
And you say that what you remember him saying is what you wrote down on that piece of paper that was found during the search warrant. What is it going to take to get you out of my hair?
Right.
You were happy and surprised, you indicated to this jury, because you've done this before, and no one's ever contacted you.
Let me recollect that.
That's what you testified to, right?
Yeah, no, I'm just saying that, yeah, to my recollection, no one has ever responded. Oh, you know what?
That's what you testified to.
No, I'm just thinking
Correct,
now.
right?
Yeah, the other responses, I had some city marshals come to my house, but it was not to those letters.
Oh,
And Marwitz had been to my house before, or I mean, the house on 441 North 16, yeah.
okay.
I mean,
So the last response, or the only other response that you got to this type of a letter was having city marshals come to your house.
It wasn't a letter of that type, though. I just wanted to be clear in my recollection.
Okay.
I'd written a letter to Judge
There was
Roger
much
of some
rejoicing.
sort, but it wasn't about this, not to my recollection. So I'm kind of like 99% sure maybe that
There was
wasn't
much
about this,
rejoicing.
but something else.
Okay, so you have an extended conversation with Mr. Federico.
Right?
You don't really remember what was said.
And there was much rejoicing.
Oh, no, I remember certain things.
We testified on direct, it's been 2.5 years, I don't really remember.
I don't remember detail for detail, but certain specific things.
And there was much
about
rejoicing.
Him asking, wanting to do
Thank you for
something
all
about
the membership
I remember
re-ups.
that specifically, I told him that would be illegal, possibly obstruction of justice.
And there was
He
much
needs to see
rejoicing.
his
You
attorney.
didn't want that, right?
Huh?
You didn't want that.
Well, I didn't want him to do it either, because it's illegal.
Okay, and
And there was much
when
rejoicing.
I mean, if he
When
had said,
asked what you would want, you said, well, at the very least, I'd want an apology in public forum.
yeah, but I really wanted to sit down and meet with him. That was the main thing that I wanted to do.
You really wanted to meet with them in person.
Now, not because I had any traction, as he made it
So
sound.
you then,
Yeah.
you then said, let me think about what I want, and I'll get back to you, right?
Well, he was pressing
And then it's
me.
a yes or no. Let me think about what I want, I'll get back to you.
Yeah, after he pressed me, he had to press me and right toward the end of the call,
Okay.
you know. I don't want to waste my time if he's.
It's okay, there's no question pending, sir.
Yeah, sorry.
And so you agreed to send him an email with what you want, right?
He told me what his email address was, and after pressing me.
Because you
he said,
needed time to think about it, right? That's what you said, right?
Yeah, I'm basing that on the fact that he didn't reject out of hand the possibility of apologizing to me for what he'd done throwing me out of the courtroom.
But you
I was sure
certainly didn't
hoping-
say, all I want is an apology.
What?
You certainly didn't say, all I want is apology. That's not what you said.
No, I was more,
You said, I'll get back to you, right?
yeah, but I was more.
Is that, it's a yes or no?
Okay, what?
You said, let me think about it, and I'll get back to you.
Yeah, after
Okay.
him pressing me.
And so, you get his email address,
He gives me his email address.
And there was much
He wants to
rejoicing.
give it to me.
okay?
As later I found out, so they
Right,
could get
hey.
it. Yeah, okay.
And can you think about it?
Thank you,
That's a
Joshua
yes.
Lee.
Oh, yes, I'm sorry.
I'm not sure the answer to that question, though.
And so you think about it, and you think about it,
I
and you
don't
keep
know if they
2
give you
days
letters of caution,
drafting up your demand of what you want.
regardless of
right?
the outcome. I don't think
No, it
that's
wasn't
the
a demand.
case.
You take 2 days drafting up what you want, right?
It's not a demand, though. I disagree with that characterization.
We can just go straight to it then.
I mean, if he just said, go jump in the lake. I
Hey,
don't
hey,
want to do
there's no
it.
question pending, sir.
Okay.
Okay. So, State's Exhibit 5, okay? This is an email, May 2nd, 2019, at 8:20 PM, right?
Right,
Okay, and this is from you.
And thank you for the
to
membership upgrade, Mando.
Michael Federico,
right.
and you did the subject draft of settlement agreement, right?
Mhm.
Say yes.
Oh, I'm sorry, yes. I'm sorry.
And then you have the body of your email, and you attached the proposed settlement agreement, as you called it, right?
Right, proposed.
Yeah. This is the document that contained what you wanted from Mr. Federico, right?
I don't think I could say yes to that.
Okay, well, you
But
drafted
because you
it.
used the-
Hey,
I'm
you
sorry.
drafted it, right?
Yeah, I did draft it.
Okay. And in here, when we look at this document, you identify yourself, Kim Blandino, is that correct?
Yeah, yes,
One of the things you identify yourself as is a volunteer unpaid investigator for the Commission on Judicial Discipline.
right, and investigative journalist.
Okay. You identify yourself as complainant, right?
Yeah,
And so every
Yes.
time in this document that it says complainant, it's referring to you, Mr. Blandino.
mhm.
That's a yes?
Oh, yes. Yeah, that's the language that was on the original I started out with.
Okay.
Explain it.
You identify Michael Federico as respondent.
Right,
You identify Michael Federico as alternate judge for Department 20 Courtroom 1C, Las Vegas Municipal Court at the Regional Justice Center, RJC, on April 25th, 2019, for the morning sessions.
right. In other words, that's when the event happened, a morning session.
And
So I don't know if he was in the afternoon session or not.
you discuss a few things right here at the top.
Mhm.
You discuss, namely under 1.1, that you're offering to settle various issues without having to involve the Nevada Commission on Judicial Discipline, right? You need me to zoom in there?
Yeah, sure didn't word that as specific as you should have. I should have said.
Hey,
involve the-
hey, that's what you said, right?
Yeah, well, I know, that's what I wrote.
That's what you wrote, okay. Then you talk about in 1.2, previously going to Mr. Federico's private law office weeks ago.
No, private is not in there.
Okay, you discuss going
How
to,
did you read private out of that? I'm curious.
you discussed going to Mr. Federico's office, is that right?
Yes,
Weeks ago,
right.
in hopes of catching Federico at said office, correct?
Yes,
To speak face-to-face and man-to-man
right.
about resolving issues from 2018 of complaint by Kim against Federico.
Right. True. I mean, yes.
Okay. So,
Oh my God.
on April 8, 2019, you went to Mr. Federico's law office to address your issues that you had with him from the trial in August of 2018.
Wait a minute, I'm sorry. You're going to have to repeat that one. I got something in my eye that distracted me.
What? Is this guy?
What's the
Oh my.
question
Yes,
again?
he is for real.
So on April 8, 2018, you went to Mr. Federico's office specifically to discuss the issues that you had with him from the August 2018 traffic trial.
We're talking about the first appearance at his public offices. Yeah, true, yes.
Do you remember when you were testifying on direct and you talked about this event and you talked about the April 25th letter that you dropped off at the office, right?
The April 20th?
25th. You remember that, right? It just happened about 2 hours ago. And during that time,
I'm just wanting to get my date clear. So the first time I was there was April 25th, or April 8th. I was there the first time, the April 8th, right?
so April 25th, you were there for the second time after court, right?
Yeah, oh, yes. I don't know why my brain breaks
And
down
so-
a second.
Do you remember testifying on direct? In my mind, I had done my duty to resolve the first incident, so now it was about the second incident. You remember testifying to that?
I don't think I said it in those words.
Okay.
It was something similar to that, but not
I
quite
remember.
those words.
Okay.
He did reference
So, here
as
you are,
him
in your
performing some sort of
side, going
duty,
on,
which he didn't have.
talking
I
about
distinctly
your
remember him
attempt to
saying that.
resolve the August
And in
incident.
my head, I was thinking, he has no duty. He's not an investigator. He's under no duty to do anything in this
Tim wrote an impromptu
action.
note to Mr. Federico to hopefully resolve issues without having to file with the Nevada Commission on Judicial Discipline. Correct?
Yes.
And then you attached a copy of that.
Thank you, Jeremy.
note. And then you went on. And we look to the second, what is marked as page 2 under agreement. And then we look to 2.1, the section that you labeled as 2.1. You see all that?
Right, yes.
You tell Mr. Federico that you need him to pay $25, correct?
Yeah, later on I say for reimbursement, but not there.
Okay,
Yes.
so you tell Mr. Federico he needs to pay $25, right?
For the repayment of the cost of the jabs, yeah.
Okay.
Yes.
You tell Mr. Federico that he needs to apologize in writing prior to May 30th, 2019. And apologize to you, right?
Yes.
And there was much
that's
rejoicing.
specifically for ordering you out of the courtroom on April 25th within 10 seconds under threat of being in contempt and put in jail, and acknowledge that you have a right to observe court proceedings in the future. Right?
Yeah, unless proceedings are specifically sealed or closed to the public, yes.
Okay, so you tell Mr. Federico that you need a written apology, and for him to acknowledge in that apology that you have a right to view all court proceedings, correct?
Right.
Okay.
Which is what he led me to believe on the phone, he was willing to
Okay? And then you also tell Mr. Federico that he needs to complete at his own expense this ethics, fairness, and security in your courtroom and community class in person in Reno, October 21st to 24th, 2019.
Yes, or in the alternative, pay $500 Clark County Law Library and give a copy of the receipt to complainant prior to October 31, 2019.
Okay? We go to the third page, as it's marked, and we look to 3.1 that says release. In there, it indicates that you hereby release and forever discharge Mr. Federico from all claims or complaints related to any and all occurrences on April 25th, 2019 between you and Mr. Federico, including any complaints to the Nevada Commission on Judicial Discipline, right?
Yes. I guess you're indicating I should have said that date and only that date. Probably would have been more specific that way, I guess.
Then at the bottom here, 3.3, you say you agree that you have not and shall not bring any other action, claim, suit, or proceeding against anyone, including Mr. Federico, in any capacity, either individually or in his official capacity for any activities on or after April 25th, 2019, including any complaints to the Nevada Commission on Judicial Discipline. Is that right?
Yes, that's the language.
And you tell them that you'll withdraw that customer feedback form that you submitted to the city?
Yeah. I don't know what that would do. They could throw those in the trash, for all I know. I very rarely get a response to those.
And then you told the ladies and gentlemen of this jury that, well, you did a cut, copy, and paste job, as you put it, right?
Oh, yes, from in a pre-existing form. I could never find the original back again.
Fair to say there was no cut, copy, and paste form for how or what you should ask for from Judge Pro Tem Federico, right? All that language was not in there.
I'm sorry, I don't understand the question.
There was no form that said Michael Federico as respondent, correct?
Oh, you're saying, could I find something on the web that has his name already on it?
Right.
No, yeah, well, yeah.
Or that admitted to all the events of April 2019?
No, that's why this is a template. This is done from a template.
But you added all that, right?
Well, like I said,
Sorry.
it's cut, copy, and paste.
Judge, you need to clarify that question. You added all that. It's a,
I mean, it's pretty clear what we're talking about. We're talking about
Do you
Mr.
understand the
Federico.
question?
Well, he's interposed an objection. Why don't you repeat the question? Maybe I missed something.
You added all the stuff about Michael Federico in here.
Oh, no. It wouldn't be added. It would be cut, copy, and paste.
Okay, so
Yeah.
you wrote it, right?
I wrote what?
You wrote all the things that we just read.
Well, I had an existing format, and I cut out certain names, and then put in other names. And
In
then
fact,
copied.
you admitted to this jury that it took you 2 days to write this, right?
Right.
Okay. And that you told Mr. Federico on April 29, 2019, that you had to think about what you wanted, right?
No, I objected to that question as asked. It's not about what I want, it's what about fair and just, and in concert with what I saw in other commission on judicial
Okay,
discipline
so
settlements.
you
So it's not
you
about
thought
what I
about
want.
you thought
Wait
about
a
it.
minute, you don't get to object to
Yeah.
Mr. Dickerson's
Oh, I'm sorry.
questions.
Okay, I'm sorry.
Okay?
You thought
When he
about
asks a
it.
question, you need to answer it.
Yeah. Yes,
And so after the call, you thought about it.
I had to. He was
Okay.
asking me to do something. I thought he was
You
asking.
had to take time to think about what.
I thought
Oh
it
my
was
God.
wanted of faith. No, not about what I wanted. See, that's what you keep mischaracterizing.
Okay.
It's not about what I want. You know, my life is not about what I want. It's what God wants me to do.
Oh
you
my
see.
God. Shut up.
And with this kind of thing, it depends on what's fair and just and proper and right. That's why it's not about what I want. The scriptures say, "My
so-
Lord is my shepherd, I shall not want." And I take that literally.
Okay. So then you told this jury that you actually went and you searched for what you call the survivability clause.
Right, that,
Because
death thing, yes.
That's a yes, right?
Yes.
Because you started thinking like, well, what if Mr. Federico dies, right?
Yeah. I mean, yes.
This $25 has to go somewhere, right?
Yes, if it was in the middle of
It's a yes?
something, yes.
And this $500 to the Clark County Library has to go
Thank you,
somewhere,
Josh.
right?
No, it goes to the law library, and if he
Well,
does.
it goes to you, right? It goes to you, and then you'll
And then I distribute it to the Clark County Law Library in total,
and
probably with some additional monies from me.
and in addition to that, you discuss here specifically his death, but you don't discuss your death.
Yeah, on reflection, I guess that wouldn't have been a bad idea.
Okay.
Should I die, the $25 would go to Evie directly. Because if I die.
Okay, no question pending, sir. Thank you.
Oh, I'm
There
sorry.
was much rejoicing.
Ha!
The settling parties, that means you and Mr. Federico, right?
True.
Acknowledge that this agreement represents a good faith settlement of issues of April 25, 2019, that this agreement is intended to bar any complaint against Mr. Federico by you with the Nevada Commission on Judicial Discipline or any court, board, agency, or reviewing entity whatsoever with respect to the issues of April 25, 2019, right?
Yes.
And so, then you included your name and his name, right?
Mhm. Yes.
And you testified to the jury on direct that you just forgot to add in the portion where that was going to be sent to the Nevada Commission on Judicial Discipline, right?
I screwed up. I didn't put that in there.
So you forgot to add the part where you're going to send this whole thing to the Nevada Commission on Judicial Discipline when you're agreeing not to send anything to the Nevada Commission on Judicial Discipline.
No, I didn't say that I wasn't going to send anything to the Nevada Commission on Judicial Discipline. I said I wasn't going to file a formal complaint. That's I've been consistent on. You know, if we can resolve things, I don't have to do the formal complaint. That doesn't mean that they can't publish a decision.
You're just really not sure how it works.
Not sure how what works.
Oh,
I'm sorry, how what
trying
works?
to get things from a sitting judge or a pro
There
tem
was much
judge
rejoicing.
that you want works.
I don't understand that question.
So your position is that Mr. Federico paid you $25.
To reimburse Evie.
Okay? Pays you $25. He gives you an apology in writing where he acknowledges that you can watch all these court proceedings, as well as goes and attends a class in Reno or pays $500 to the Clark County Law Library. In exchange for that, you're not going to file any complaints with the Nevada Commission on Judicial Discipline. Right?
In exchange for? I don't know if I could, let's see.
Think about
Wait a
it.
minute, what did you, repeat that question again?
We've now moved on from the impersonation to now the extortion bit.
Repeat the
You
question
heard the
again?
question, sir.
No, I'm sorry, I do need it repeated, I'm sorry. I want to make sure I am totally accurate and totally truthful in this answer, so repeat that question again, because I think you're trying to trick me into admitting to something that's not true. I'm sorry, Judge, but if he doesn't want to repeat the question, I really,
Listen. You ready?
you're going to
Look in
repeat the
here,
question?
States Exhibit 5,
Yeah,
all right? In consideration, you used that term, right?
okay,
Okay?
that's the one that was in the original I started with.
Yeah. you will accept $25 for the jabs, correct?
And he gets the jabs.
Hey, it's a yes or no, right?
Yes.
In consideration, you will accept $25.
Yes, and he
Okay,
gets the jabs.
hey, and then in addition to that, Mr. Federico will apologize to you in writing prior to April 30th, 2019, and will acknowledge.
No, May 30th.
I'm sorry, good, thank you for correcting me. He will apologize in writing prior to May 30th, 2019, and that he will acknowledge there that you have the right to observe the court proceedings in the future, correct?
Right.
And further in consideration,
Yes.
Mr. Federico will complete this class in person in Reno on those dates, or pay $500 to Clark County Law Library and give you a receipt.
Right.
Prior to October 31st, 2019, correct?
Right. Yes.
Okay. And as in consideration for the promises made herein, you will not file any complaints, including any complaints to the Nevada Commission on Judicial Discipline against
But you're
Mr.
still
Federico.
in there, you see, any and all occurrences on April 25th, 2019.
So the question, sir, was, Mr. Federico gives you $25, gives you a written apology acknowledging that you can watch all the court proceedings you want in the future, and
Not true, I mean, don't mischaracterize.
he completes the class or pays $500 to the Clark County Law Library, and in exchange for that, you won't file any complaints with the Nevada Commission on Judicial Discipline.
No, that's not true. I will not file any complaints about anything April 25th, 2019, because he had thrown away his opportunity to resolve anything on the initial thing at the trial. And maybe that's what I should have been clear on, that I still intended to file a complaint because he had slapped me in the face the second time, as I referred to the jury on my direct testimony.
Okay.
So that
So,
there
let me stop
was
you
no
there.
quid pro quo, Mr. Prosecutor.
Let me stop you right there. So.
But you admitted
that
there
it's true,
was.
then, that you just were going to limit what complaints you were going to file. You were just not going to file the complaints for April 25th, 2000.
That's what the agreement says.
Okay, so he gives you $25, he gives you a written apology acknowledging that you can watch future court proceedings. He goes and takes the class in Reno, and he pays $500 to the Clark County Law Library. In exchange for that, you won't file any complaints with the Nevada Commission on Judicial Discipline for any of the events of April 25th, 2019. Fair?
Only for that. Yes.
All right, and so a couple days go
No
by
further
to that,
questions.
and you have not heard from Mr. Federico. Well, I guess I should clarify, just the next day, just so that we're there. Here's State's Exhibit 6, just the next day, May 3rd, 2019. You do the follow-up email to Mr. Federico, is that right?
Oh, yeah, this is the follow-up where I said I forgot to put the exhibits attached.
Okay.
That's how tough a part I was working at.
And that was at 3:27 PM,
Right,
and you had the attachment, right?
right.
And then we flip the page, and this is the same settlement agreement and release as you titled it.
Right, with the exhibits, now this time.
You haven't added any language about you still sending this to the Nevada Commission on Judicial Discipline.
No, I don't believe I did. I think I just attached the thing, the exhibits, and put it in a PDF and sent it.
Okay.
Yes.
And then you attach the exhibits, including the April 25th, 2019 letter that you dropped off at Mr. Federico's office,
Right,
including your customer feedback form.
right, yes. Yeah, that's exactly what I intended to send the
And
first time. and screwed up.
the original attachments of the April 25th letter, right?
Yeah.
And then the copy of the note that he left on April 8th.
Right, yes, so he has everything in one package, so you can see it.
Okay, and so, it's the April 8th letter that you attached as an attachment to it. April 8th, 2019, you were ready to begin filing your complaints against Mr. Federico, right? You said it right there, first line. I am ready to begin filing my complaints
Well,
against.
yeah, to begin filing it, which,
Is that a yes? It's a yes or no?
yes, I should have said.
Okay, so, I'll stop you there.
Writing it.
April 8th, 2019, the events of April 25th, 2019 had not occurred yet, right? So yes or no, it's an easy question.
You're saying the April 8th, the April events of April 25th hadn't occurred yet? Yeah, I don't have the worrying of the flux capacitors. I'd have to answer yes.
So the complaints that you were ready to file were about the August 2018 events, correct?
You know, I'm objecting to characters of complaints. I believe it says complaint in that, may I see that?
So your objection is to the plural form?
Yes, he's saying complaints, and I believe that letter just says complaint.
Okay. Yeah, I'll accept that. So the complaint that you were going to file was for the August 2018 events at the traffic truck.
You mean the one I'm referencing in the April 8th letter?
Yeah.
Yeah, because the other event hadn't happened yet.
And you attached that letter as an exhibit to the demand.
No, it's
There was
not
much
demand.
rejoicing.
It's a settlement agreement that
Thank you,
he
Josh.
asked for, or I thought he was asking for, but
Okay.
it turns out he wasn't.
Okay. So a couple days go by, and you have not heard from Mr. Federico, right?
You're talking about after this May 3rd follow-up?
Yeah.
What was it, 5 days, are you saying?
Said a couple.
I thought I sent the next thing on the May 8th.
Well, you started working on your next letter, right?
I don't recall.
You started working on your next letter as a follow-up to the demand.
Well, again, there was no demand, it was a proposed settlement.
And while you were working on that letter, you got an email on May 9th, 2019 from Mr. Federico.
Oh, the global agreement request.
Yeah.
Oh, yeah, that's true, yeah.
Yeah, you got that while you were working on the letter.
Right, yeah. It
And
took a while to write, too.
like 2 days or so, you said?
No, when I was, in that one, I recall, I was saying, you know, I'd begun writing, when I got his email, I said, I'd already begun writing this letter. That's why I think I didn't update the date of that letter, so the date I actually sent it out, it was actually the date from before, which I do sometimes in my legal work.
Yeah, you've been working on it for a couple of
You
days.
forget to change the date on the bottom, and you gotta cross it out, or whatever, sometimes you forget, you send it in the wrong date.
Yeah, so the letter that you attached to your response to Mr. Federico on May 9th, 2019, you've been working on for about 2 days.
I don't know how long I've been looking for that one.
Sometime, you said it took a while, right?
Yeah,
Okay.
I bounce in and out of it sometimes. You get phone calls, you get this, you get that.
Okay, so here we have State's Exhibit 7. Here's the May 9, 2019, at 9:20 a.m. email from Mr. Federico to you. Is that it?
Okay, yes.
This is where it's like, hey, please provide a global agreement that would cover anything in the past that you believe negative against me so that I can see it. Right?
True, yeah.
Your current proposed agreement does not resolve everything you seem to be complaining about, right?
Yes,
And you'd agree to that as well? That it didn't seem to include everything, right?
I'm sorry. Yes, it appears as though
Okay, so then we'll go from here.
he's wanting.
So now it's May 9th, 2019 at 9:20 a.m.
Right.
1 hour and 28 minutes later, you respond to Mr. Federico, is that right?
Oh, yes.
You write, Michael, here is a letter I was just about to send you before I read your email. I think it covers some of your concerns. Right?
Yes.
I must be leaving very shortly. Yet, so I am not spinning my wheels, I do need to know if a written apology and the Judicial College Law Course Law Library donation is a, quote, bridge too far, unquote, for you as it stands.
Yeah, that's a British term from World War II.
That's what it says?
I'm sorry, yes.
Okay. I now have the jabs and I'm ordering a transcript. What I'm asking for is consistent with remedial action the Nevada Commission on Judicial Discipline has effectuated over decades.
True, yes.
I am willing to be flexible and reasonable, yet if the things I propose are a non-starter for you, I do not want to move forward down a dead end.
Exactly, so if he says no, jump in the lake, I file my complaint. Case closed.
Right, if he doesn't give you what you want, you file your complaint with the Nevada Commission on Judicial Discipline.
No, not what I want, again, I object to that characterization, that's not.
You were the one
And
who,
again, you don't get to object.
Okay, well then I'm gonna have to answer no then, no.
so, just to be clear,
I'm sorry, I apologize, I got a little bit heated there. Let me reiterate, no. I'm
no
sorry.
what?
It's not what I wanted, no.
What do you mean no, it's not what you want?
It's not about what I wanted.
You're the one who wrote the demand.
I didn't write a demand, no.
You wrote what you titled settlement agreement or release.
How is an agreement a demand?
You wrote that, right?
That's not a demand, no.
You wrote that, right?
I wrote the proposed settlement agreement, yes.
Okay. And if he didn't want to agree to it, then you just file your complaint.
Yes,
So then you attach the letter, May 8, 2019. Is that right?
Oh my gosh.
That's what the date is at the top of the letter?
oh, yes,
Though you emailed this on May 9th, 2019.
right, I told them I had started working on it, and that's kind of the evidence that I did, because I had a date and I forgot to change it.
Yeah, because you were going to send him this letter before he ever emailed you on May 9th, 2019, right?
I had intended to mail it on May 8th, but if I couldn't mail it, and I didn't get that intervening email, probably would have changed the date, maybe mail it on May 9th. That oftentimes happens with me. I start something, I have to change the
No
date.
worries. You already had it completed, though. You were good to go, right?
No, I don't know if it's completed. It was mostly completed, probably. I maybe had to put a few things on it.
Okay. And then you title it to Michael Federico in his capacity as a judge pro tempore, right?
Yes, yes,
From Kim Blandino,
right, yes.
regarding follow-up to proposed settlement offer sent May 2nd and 3rd, or May 2
Yes,
and 3, I should
yes.
say.
Proposed settlement offer, not demand, yes.
And then here at the top of this, I have not received any word back from you regarding the proposed settlement offer. That's what you wrote?
Yes,
I spent a great deal of very valuable time preparing that document. That's what you wrote?
yes.
I will need an answer or for you to otherwise respond to this proposed settlement on or before May 23, 2019. That's what you wrote?
Yes,
You acknowledge then you appreciate the phone call that he gave you.
Judge, I'm having trouble understanding something here. I mean,
Uh,
it's not, I can't understand this.
What's going on right now?
You can read that letter, but I can't on my direct testimony, and you
Mr.
cut me short.
Blandino, you get to answer the questions.
That doesn't seem fair to me, Judge.
Okay.
Oh,
you
no.
get to answer the questions.
Oh,
presented to you.
yes.
But you're letting him read all this stuff.
Mr.
Hey.
Blandino.
Yeah.
Read mine, and
Mr.
I don't think I'm being
Blandino.
treated equally here.
Come on, okay. Mr.
I
Dickerson,
object to this.
you object to what?
The fact that you don't seem
You
to
don't
be
get
following
to
the judicial
object.
code and treating parties equally.
Okay,
Oh my
That's
God.
my perception.
that's fine, you can have it. Mr. Dickerson, you can repeat your question?
Thank you very much, Your Honor. You told Mr. Federico, I do appreciate your phone call to me to at least reach out to settle matters, and I sincerely hope that we can settle things.
Yes, that's true. That's the way I felt. I thought he was being sincere. So that's consistent with what I've said all along.
Then you write, please note that I'm doing this more for the people that follow me. Right?
Yes.
You wrote
yes.
that?
Oh, yeah, yeah, yeah. Can you understand that?
And then you write,
You don't get to ask questions yourself, Blandino.
Offer for something very serious. Is that right?
Yes.
And then you write, in fact, you can be criminally prosecuted for a misdemeanor violation of federal civil rights under 18 U.S.C. section 242 for your actions on April 25th, 2019.
I believe that's true.
You wrote that, right?
Yeah, I believe that's true. I've seen it for prosecutions for something even less serious than that by judges. It's a violation of civil rights, criminal violation. Detective Meade testified.
Hey, there's no question pending, sir. Thank you very much. And then we get to the next page.
He's definitely
I have told
getting
you
snippy.
that if you cannot settle this matter, I will file a complaint with the Nevada Commission on Judicial Discipline.
Yes,
You wrote that.
yes,
You say, this must be done to protect other people in the future.
yes.
Then you go on. If we cannot come to a settlement, I believe it would be proper to go to the FBI with a criminal complaint against you for stopping me from observing you on the bench.
FBI?
April 25th, 2018. You
What?
wrote that.
Yes. Doesn't mean I said I was going to file one. I just said I believe it would be proper.
Okay, please just
Oh my God.
Yes.
Granted, this would only be a misdemeanor. However, it may help others that will come after me, should you not agree to the apology and settlement. You wrote that?
Yes.
Since it is possible you could become a decent judge someday. You
Yes.
wrote that?
Yes.
I think what Dickerson is trying to do is that with the entire cumulative effect of the letter, it's establishing that this was intended as to convey to Federico, change your behavior or else I'm going to bring the hammer down on you and pay me $25.
To an agreement, then you wouldn't have believed that it would have been proper to the FBI.
That sure is some awkward and not very precise language on my part.
That's what it said, right?
No, that's what I wrote, but I think that's...
That's what you wrote? Okay.
Yeah.
So then we go on to the next
That wasn't
one.
very well thought out.
So, additionally, I have come to realize that since you work in a partnership titled Olson, Cannon, Gormley, and Gulo and Staversky, which you abbreviated OCGAS, right?
Yes.
That I should give some notice to these individuals of the matters involved prior to filing with the Nevada Commission on Judicial Discipline or the FBI. You wrote that?
Yes.
The calculus for this is simple. Putting myself in the place of any one of these partners and everything else being equal, I would want to know that a person who worked with the firm and had a prominent web page was not bringing any disrepute in any way to the firm or its name. You wrote that?
Yes.
Olson, Cannon, Gormley, and Gulo and Staversky has been in existence since 1960. It would not be fair or Christian of me not to inform the firm of the issues at hand if we cannot resolve them. You wrote that?
Yes.
I have no idea what agreements there are between you and Olson, Cannon, Gormley, and Gulo and Staversky. I therefore have no idea if your agreements require you to disclose any of what we have discussed so far or not. Because the issues involved could affect how Olson, Cannon, Gormley, and Gulo and Staversky might be perceived by the public, I believe I must give Olson, Cannon, Gormley, and Gulo and Staversky a right to review prior to taking this matter forward. You wrote that.
Yes.
And you wrote that you recognize that it could bring disrepute, these things, if perceived that way by the public. Correct?
I'm sorry, I lost it. Where did I say that? Or right there?
Right here, so you acknowledge that all these things, the Nevada Commission on Judicial
Oh, you
Discipline,
went backwards then?
and FBI complaints that you're talking about,
Oh, okay,
could bring disrepute. You wrote it right there, right?
okay.
Is that a yes?
Wait a minute, let me see.
You wrote that, disrepute.
I'm just trying to read the language here. Yeah.
Okay.
What it's showing there is, I don't know what you said just a minute ago, if you transposed the words.
Yeah, that's what you wrote though, right?
Okay. What I'm reading right here is what I wrote.
Okay. And that you recognized how these things could be perceived by the public, right?
Yes.
And then, so you say that to be fair and Christian, you need to notify his firm.
Yes. Which I should have done earlier, and I stated that in my direct testimony.
Then you go on, therefore, consistent with my beliefs, I will send a copy of all the relevant documents to Olson, Canning, Gormley, and Gulo and Staberski. Right? You wrote that?
Yes.
Unless I hear from you by Monday, May 15, 2019. You wrote that?
Yes.
Okay. And then you write, you go on, I can state with certainty that if I were any one of these partners and Federico did what was done on April 25, 2019 to any human being, I would be very displeased with such action.
Yes, I wrote that.
I would want remedial action as soon as it was possible, and if it was possible. Right?
Yes.
I would not want anyone associated with a firm that had my good name on it associated with a member of the bar that excluded a member of the public from an open courtroom, let alone an investigator and journalist from a public courtroom because said person came to a private law office in a good faith attempt to settle differences and a complaint.
Jews, I don't think there's a copy
Yes,
on,
that's
that's
true.
available
You wrote that.
online to get that letter.
Then I believe that now.
Probably, maybe you might be able to access it
So-
through a request after the.
Yeah, you believe that if you
after
were
the
a partner
trial.
in that law firm, you wouldn't want Michael Federico associated with the firm if you knew what you knew, right?
No, I wouldn't want a guy doing that to anybody,
Yeah, and so,
under any circumstances.
so you figured as soon as the partners found out, they were gonna be pretty upset, right?
No,
Okay,
not
so then you,
necessarily.
so then you go on, I am sorry I have to cut this letter short. I have worked on this letter now over the course of 2 days,
Okay, yes.
and then you sign it and date it.
I have to get, wait, I have to get to the courthouse immediately, I think I wrote there.
Yeah, you gotta get to the courthouse immediately. Right, you wrote that?
Yeah, and then, can I read that last line? Please excuse any and all spelling, grammar, and other errors. I virtually have no time but to sleep and eat, sleep, and do legal work. Which is true.
Sleep, and do legal work, right?
Virtually no time but to do that.
You're not a lawyer,
No,
you don't work for a law firm,
no.
but that's what you do. Eat, sleep, and do legal work?
Yeah, I have my own cases going.
Um,
And I consider the Commission on Judicial thing as legal work because they're part of the judiciary branch, or the branch
You
of the
do
judiciary.
realize that you don't work for the Nevada Commission on Judicial Discipline, right?
Not on an official capacity, but unofficially, yes.
Okay.
And they've asked me for investigative stuff in the past.
You realize that you also do not unofficially work for them either?
No, unofficially, yes, I do.
No.
I'd be better probably to say with
There
them
we
rather
go.
than for
Again.
them. And I've used with as well as for. And with is probably better because, like, he was working with the police.
Okay, so I'll
to
stop
get
you
these
right there,
charges.
that's non-responsive.
Yeah.
Now, you send that letter over.
They emailed it, yes.
And then you want
Take
to,
the bathroom break here soon.
Do you need a break?
Yeah, I've been drinking quite a bit of water. Goes in and goes out.
how cold's that water? Do you need a new one?
Oh, well, no, water's okay, I'm just,
Okay.
we need the
Can I
bathroom
just
break.
have the attorney's approach for a moment?
Oh, it's 4:45, I didn't realize that late. I may be able to hold it till late. Okay.
She's probably
Oh,
asking him how long is this going to take, because there's about 15 minutes left before the end of the day. But it wouldn't be surprising that this may go into tomorrow. Well, it sounded like Dickerson was getting. I thought he was getting ready to end his testimony like 10 minutes ago, but he's deciding he wants to go through the entirety of the letter. So this may end up going into tomorrow morning, and then I imagine Dickerson's going to bring in those additional pieces of evidence and witnesses to coincide what Blandino effectively gave away during his direct testimony.
yeah. I kind of think that maybe, and correct me if I'm wrong, but considering all of the nonsense that Blandino has put Dickerson and everybody else through, Dickerson just going line by line is essentially just giving back to him what he's given to the court.
Probably.
I do have to say, though, you have to have a masterful way to turn a traffic ticket into almost 11 years in jail.
Yeah. All right.
Thank you. Am I coming back then?
Sure, you can come down.
Okay, thank you.
We are going to conclude for the
Yep.
day. During this recess, you're admonished not to discuss or communicate with anyone, including your fellow
That's what I
jurors,
thought.
regarding the case or its merits.
So yeah, it looks like they're wrapping up, and we're probably going to be continuing on tomorrow morning.
Communication or social media, or read, watch, or listen to social media accounts.
Yeah.
Or commentary about the case, or do any research such as consulting
I do have to say,
dictionaries,
though,
using the
it
internet,
gives
using reference
Blandino a
materials,
little bit of
making
time to
investigation,
rest this off,
testing theory of the case, recreating the
go
aspect of the
home
case, or
and
in any other way,
think about what he's done.
investigate or learn about the case
I
on
mean,
your own.
especially if they were able to continue on, let's say, for what, another hour. I mean,
That assumes he's
It's almost-
capable of introspection. I'm not
Right.
so
my
sure.
wife's directing her.
yeah, I don't think so either. But he didn't really get the opportunity to do what he does in a lot of the court cases, and that is to run his mouth. He got to do it when Ben allowed him to go through with his narrative, when the judge allowed for that, which I thought was really a poor idea to let him push that narrative, especially the opening statement that he gave to the jury.
Yeah, right. Yeah. So that's what I figured. It's going. I don't know what's going to happen tomorrow. Okay, and my food just arrived. So, guys, thank you very much. Mandy, go for the super chats, and then I'm gonna get my food.
Okay. Pull these up. All right, I've got Joshua Lee with a $5 super chat. That's not Kim. That's a copy of Kim. I've got Dr. Strangelove with the $10 super chat. What's a train wreck? He's going down in more flames than the Hindenburg. Past the popcorn. Joshua Lee with the $10 super chat. This is priceless. Such a glorious train wreck. Joshua Lee with the $5 super chat. Face palm protection ready. Joanne Sal with the $2 super chat. Thank you, Joanne. Joanne Sal with the $2 super chat. But what about the swivel chair?
What about the
Okay.
swivel chair, Artie?
Not
I
really
know
Did you ever
nothing
use the
about
swivel chair
that.
defense?
I know nothing about this swivel chair. I'm actually completely in the dark on that. So
He was referencing that the chair was a swivel chair, so that way he could say that he was not ignoring Judge Federico, that he was looking into the audience, so that way they could confirm that they also saw that Federico did not have a nameplate.
Oh gosh,
okay,
Yeah.
please
that's the
continue
deal with
on.
the chair.
At least that's what I gathered from it. I'm willing to be wrong.
Joshua Lee sent a $5 super chat. I called the police, therefore I am a detective. Blandino, 2022. Air Scout with a $1.99 super chat. Comcast happens already. It does. Manda Cullen sent a $3.58 super chat. Why not just pay the damn traffic ticket in the first place? No waste of money and time.
Well, no,
True,
that's
Amanda.
as much as we want him to do that, his pride and narcissism is going to get in the way of it because he wants his damn apology.
Mm.
Look at what he's been through. Akira 808 State became a member. I think a lot of these are renewals. Robert Bridges became a member. Thea Tama became a member. I missed one. Hollery USYW became a member. Sunflower 19 became a member. Joshua Lee sent a $5 super chat. Artie's Corporate Fiction and Keeping It Criminal. Don't they send letters of caution in all investigations, regardless of outcome?
Yeah, I'm not sure about that. I don't think they do. No matter whether or not the complaint has substance or has been substantiated. I don't know about that, but I'm not sure.
Yeah, I'm not 100% on that either.
Okay. Tom Castro sent a $10 super chat. This clown had Natalie wanting to drink earlier. He needs to meet P. Barnes and his pal, Mr. Sparky, or his pal Sparky. I put Mr. in there myself. I agree. Joshua Lee sent a $10 super chat. Kim Blandino puts quantum grammar to shame with his semantics. Agreed. Pronon 1990 sent a $1.99 super chat. Thank you. Joshua Lee sent a $10 super chat. Get some wings, Artie. I think he has wings now. I don't, but he does. Paul Berry sent a $2 super chat. I'm unofficially, voluntarily here from Mike's chat. Joshua Lee sent a $5 super chat. In my opinion, Kim's religion describes him perfectly. He wants all the benefits, but none of the responsibilities. Very well put, actually. Joshua Lee sent a $5 super chat. Artie David, when Miller called, he conceded defeat to Kim Blandino. Paul Berry sent a $2 super chat. Kim is from New Jersey. Are you guys drinking buddies?
He's from Nevada, not New Jersey, so no, we are not drinking buddies.
Thank God. Could you imagine that?
Oh,
I'm guessing no.
No.
Deacon said that's a good one.
Yeah.
Okay. Thank you, guys.
And thanks to our Nevada judges for allowing Artie to bring this up. And thank you, Artie, for having me on to kind of sit and watch this with you and suffer.
Yeah, of course.
Right alongside you.
So yeah, I'm probably gonna miss the last bit of the trial. Oh, he's from New Jersey originally. Well, neither am I, so it still doesn't count. So the issue is, I'm probably not gonna be able to watch the rest of his testimony. It seems pretty obvious that it's going to wrap up or getting close to wrapping up tomorrow, but you never know. But we'll see what happens. And yeah, thanks a lot, guys. I appreciate it. Sorry for the Comcasting. Hopefully, well, we all know I'm at the mercy of, the conglomerate at this rate. So, but thank you guys again. Have a good night. I'm gonna eat my food before it gets cold.
Like and subscribe before you leave.
Take care. Hit that like button on your way out. Adios.
Adios.
What? Shut up. Take that.
A pimp, not a